Good morning and welcome to WorkCover Queensland's Common Law webinar for May, which is about managing workplace injuries to improve outcomes. My name is Tim Lose. I'm a lawyer with WorkCover Queensland and I will be your host today. Before we get started, I would like to acknowledge and pay respect to Queensland's elders past, present and emerging. We thank the traditional custodians of country throughout Australia for their ongoing custodianship of land, waters and community. Today's session will be recorded and we will send a link to the recording out by email early next week. It will also be uploaded to the WorkCover Queensland YouTube channel. You may submit questions during the webinar using the panel on the right-hand side of your screen. If time permits, we will go through some of the questions with our guest presenter at the end of the session. Your questions help us in planning future webinars for the year, so keep them coming and also provide your feedback. Today's guest speaker is Kerrie Jackson, Director Principal at BTLawyers. Kerrie specialises in commercial law, insurance law and insurance litigation. For more than 16 years, she has acted for both plaintiffs and defendants in workers' compensation, superannuation, disability insurance, medical negligence, motor vehicle accident claims, property damage, public liability and a range of general insurance, commercial and contractual disputes. Welcome, Kerrie, and thank you for taking the time to prepare and present for us today. We will also have WorkCover's own Matthew Darville joining the conversation towards the end. He's going to talk about his role as early investigation coordinator. Before I hand over to Kerrie, I would just like to remind our listeners that any advice given or questions answered today by WorkCover and BTLawyers is general information only and should not be taken as legal advice. All right, that's all from me for now. I will now pass over to Kerrie to talk more about improving claim outcomes. Over to you, Kerrie. Thank you.
Thank you very much, Tim, and good morning, everyone. I'm really grateful to have the opportunity to speak to you today about an issue that is close to the heart of, I think, all panel lawyers that have the privilege of doing WorkCover's work. And I think if you'll forgive me, we'll start with some first principles to remind ourselves why this is so key, and then have a look at the impact of claims investigation at various stages throughout the life of a claim. So obviously, to start at the statutory compensation level, obviously lawyers would never end up getting involved if there were no statutory claims. So a reminder, I guess, at the statutory level that the scheme is no fault, so that an injured worker does not have to prove the fault of any person in order to establish an entitlement to statutory compensation. Workers must demonstrate that they've suffered an injury within the meaning of Section 32 of the WCRA, the Workers' Compensation Act. For a personal injury to be an injury within the meaning of the Act, employment must be a significant contributing factor. So employment has to be more than just the setting of the injury. It must actually significantly contribute to the injury. And I guess these are the principles that sort of guide us from a preliminary level when we're investigating injury or claims of injury at work. And I've just mentioned there that there are exceptions for psychological injuries, so that a psychological injury that results from reasonable management action taken in a reasonable way is not an injury, even if employment is a significant contributing factor. And I'll come back to that because that'll be relevant in the context of what you need to investigate and what evidence you need to gather when claims of a psychological injury are made. So moving on, determining an injury for the purposes of statutory compensation. So an employer receives notification of an injury, a report of an injury, a claim being made, or receives notification from WorkCover that an injury claim has been made. The employer has a limited period of time to take action and to investigate and to determine what attitude should be taken to the claim. So when in the period before an application for statutory compensation is accepted by WorkCover, the employer must quickly consider any investigations, reports and statements regarding the incident and whether or not the incident or an injury occurred. And as I mentioned, the employer has, if they intend to dispute a claim, a limited period of time to provide evidence to WorkCover to explain why they dispute the claim. It's important to note that claims cannot be unaccepted. Once WorkCover has made the decision to accept, the acceptance cannot be rescinded by WorkCover. The challenge that is, or the right that the employer has at that time, is by formal review. That's why it's important, we say, to put all relevant information to WorkCover prior to claim acceptance. And I've just mentioned there that there are 20 business days to make a decision once the claim has been lodged. And I mentioned again there that the employer has rights of review if they're not satisfied with the decision that WorkCover has made. So things to think about when a statutory claim has been lodged. Is it an injury within the meaning of the Act? So was there a personal injury? Is employment a significant contributing factor to the injury? What do you know about the worker's prior state of health? What do you know about what the worker has been doing outside of work? Whether there are any other factors that may have caused or contributed to the complaint the worker now claims that they have. Was the injury reported after a public holiday or after a weekend or after a period of time away from work? Are always things to consider. Is there any objective evidence that the alleged incident causing the injury occurred? So that's a really important one. Was it reported at the time that it happened? Who was it reported to? How was it reported? Is the mechanism that was reported at the time consistent with what is now being reported to WorkCover? Has a statement been provided by the worker? If so, when was it provided? How was it provided? And again, is it consistent with what is now being reported to WorkCover? Is the explanation for the mechanism of injury clear? Is it possible to understand what the worker is saying happened? Is it an aggravation? If so, again, what do we know about the pre-existing condition? Is it identifiable on pre-start work medicals? Is there evidence of it in medical certificates that have been provided, or just our knowledge of the worker during the course of their employment? Is further expert medical evidence required? Obviously, the employer doesn't have the opportunity to arrange examination of the worker at the time of the lodgement of the statutory claim. But if the employer has some concerns about the veracity of whether the incident occurred, or if it did, whether the worker actually sustained an injury, should the employer be talking to WorkCover at that point about whether further medical investigation should be undertaken prior to the acceptance of the statutory claim? The employer needs to consider at that time whether further factual investigation is actually required before the acceptance of the statutory claim. If we've got concerns about the veracity of the claim, are there witnesses or co-workers that we ought to talk to, or managers, or other documents that ought to be gathered so that we can determine whether or not the claim is one for acceptance or rejection? It's worth knowing the employer's rights of review and appeal, and every time WorkCover makes a decision, the last page of the decision will have the employer's review rights if the employer wants to challenge a decision that's been made. And then the employer needs to make a decision, I guess, whether contesting the acceptance of a statutory claim would be worthwhile, and that becomes relevant in the context of common law claims, which we'll discuss later on. And then there's another issue there for employers, that if the claim is accepted, how do we return the claimant to meaningful work? Because we've all identified that returning the worker to meaningful work at an early opportunity is one of the greatest factors to reducing common law claims. So an accepted statutory claim is the gateway to a common law claim. So in order for a worker to make a common law claim, they have to have an accepted statutory claim. They have to have demonstrated to WorkCover that they've sustained an injury within the meaning of the Act. Once they've done that and they've had their statutory claim, the worker's been had all of their treatment and then been assessed as stable and stationary, and WorkCover issues the notice of assessment, which can contain a small offer of lump sum compensation depending on the percentage of impairment that is accepted. If the worker accepts that offer of lump sum compensation, they extinguish their right to common law damages. However, as I guess most people listening to this would know already, the worker has the right to defer the offer of lump sum compensation and to proceed instead with a common law claim. A common law claim potentially is a much larger claim than a statutory claim because it includes a series of categories of compensation that can't be claimed during the statutory claim, and we'll talk about those in a moment. But in order to be successful in a common law claim for damages, the worker must prove negligence. Well, actually must prove three things. One, that the employer did something wrong, and the lawyer's word for that is negligence. Two, that what the employer did wrong caused the worker to suffer an injury. And three, that the injury caused the worker to suffer loss. So breach, causation, and damages. And they're the issues that are being investigated by the time the claim gets to the common law stage. So it's trite to say that employers have one of the highest standards of care imposed upon them, and it's because of the position of power and control that an employer has over an employee, and the position in which the employer puts the employee in the course of their employment. So the common law duty of care requires an employer to avoid exposing employees to the unnecessary risk of foreseeable injury. So these are usually what the duties I've got there are the duties that the employer must perform in order to discharge their duty of care to the worker. So to provide a safe place of work, to devise a safe system of work, to provide adequate training and instruction, to supervise employees to ensure they comply with the safe system of work and the instruction that's provided to them, and to provide safe plant and equipment. And then I've just mentioned their employers are also vicariously liable, so will be responsible for the negligence of their other employees if those negligent acts arise in the course of employment. So when we're conducting factual investigations with you at the time a common law claim has been lodged, these are the types of issues that we'll be asking employers about. So information about the place of work, the system of work, the training and instruction, the supervision that was provided, the plant and equipment. And some of the information that we'll be asking you for and some of the detail seems very granular because we're basically trying to, reconstruct step by step how an employee says that they were injured, exactly what system they were working in, and exactly why the incident occurred. So from an employer's perspective, there are a whole bunch of investigations that need to be conducted at various stages, and not just at the time of the lodgement of a common law claim. Employers will need to do investigations when a whole bunch of scenarios present themselves, and so they include, as I've identified, injuries to workers, but circumstances in which customers, suppliers, and contractors are injured. Near misses or problems with equipment, bullying and harassment, complaints by clients, and disciplinary issues. And it's important to have a proper system of investigation when any of these circumstances arise in the event, I guess, of legal action. These areas are typically where we see legal action, so proper investigation when these sorts of issues arise can assist employers to defend themselves from these issues down the track. So obviously, why do we investigate? From an insurance lawyer perspective, we say to minimise liability, but of course there are a whole bunch of important reasons why we conduct proper investigations into these types of incidents. Obviously, safety and continuous improvement. These claims, common law claims can present a great opportunity for learnings to improve systems and to improve workplaces for all workers. We always want to minimise workers' compensation claims where we can, comply with workplace health and safety reporting requirements and our obligations in terms of potential prosecutions. From the panel perspective, investigations are absolutely key in defending common law claims, Fair Work Action and Human Rights Commission complaints. And for issues involving management and HR disciplinary processes, proper investigations can be important. So from a common law perspective, then, our investigations centre really typically around these things. So statements, and they're usually contemporaneous statements of all people involved, so the worker and any key witnesses. The documents that we will request from you during the investigation of a common law claim include personnel file, risk assessments, training registers, manuals for equipment from time to time, but key documents, I guess, relating to the system of work or the incident reports and risk assessments, those sorts of things. Physical evidence, if there is a piece of equipment that's defective, or an area of flooring that's a problem, or weights and measurements of items that are involved in the incident. Often we'll ask you to gather evidence about those sorts of things. And photographs and videos. So photographs of the area, video of the work task is something that you might be asked for during the course of a common law investigation. So you've had a workplace incident and you need to conduct an investigation. Where do you start? Obviously, if your claimant or the worker is so injured that they can't provide a statement, that'll have to happen down the track. But absolutely, where you can, it's good practice to start with a statement from the worker. That should be a first-person account in their own words. So if they're often workers are too injured or too upset or distressed to write the statement themselves, even if it's written down for them, it ought to be in their own words, and it must be signed and dated by the worker. So like, these sound like basic things, but we see them in the context, I guess, of problems with evidence down the track. In a lot of industries, and I mean, it sounds trite to say identify the full name of the person giving the statement, but in a lot of industries, nicknames are absolutely rife, and we see a single handwritten statement with a one-word nickname, and then 3 years later, when the common law claim is lodged, we're going to track down, a bloke called Kiwi from 2019, which makes it, extraordinarily difficult to find. So the full name of the witness, the position that they occupy, and the contact details of the person giving the statement. The reason why they're providing the statement is absolutely key. So were they there? And if they weren't there, are they just reporting what they were told by the worker involved in the incident? We say that if you're uncertain as to whether to include details in the statement, include them. I guess what I mean there are details that you are told by the person who is giving the statement. What I don't mean there is speculation about what you think happened or why it happened or what could have been done differently. If there is any contemporaneous factual evidence and you're not sure whether to include it or not, include it, because it might assist you down the track in the context of the common law claim. It's important to take a statement from everyone who directly knows something about the event. So not everyone who heard about it afterwards or dealt with it in the aftermath, but everyone who was there, everyone who spoke to, I guess, the claimant directly afterwards, or anyone who was participating in the event. When you are taking your statement, I've just said keep an eye out for some yellow flags. And this is where you might want to direct, I guess, a little more attention and effort in your investigations, where you see there is a delay in reporting of the injury, where there's a prior history of a similar injury, where the person who's reporting the injury has ongoing HR issues, or the statements include conflicting evidence. They're the first sign, I think, that this claim might be problematic down the track, and in those circumstances it's important to record as much contemporaneous evidence as you possibly can. The contemporaneous statement of the worker is absolutely key, because it's taken at a point where the incident is completely recent in time and the worker has not had the opportunity to see their union or see a lawyer, and not that you want to shape their version in any way, but it's just that they haven't had an opportunity to reframe or reconsider how they might want to present this later on. And these are the documents that are absolutely key in terms of common law investigations down the track. So when you're taking a great statement, here are some things to think about. So firstly, who do you need to talk to? So how were they involved? Where was this person? What did they do? And what part did they play? Again, it's really important to be careful about sorting out why somebody is relevant and how they know what they know. A chronological sequence of events is really powerful. Making sure that the person who's giving the statement leads you through the events that happened in a way that flows and makes sense can really help down the track. Be specific, and I mean, you don't want to shape the evidence of the person who's giving the statement, but you do need to test them a little bit. So, you know, how do you know that, I think, is one of the most powerful questions that you can ask a witness when a witness is providing a statement, and address their inconsistencies. If you're told at the beginning that the box weighed 20 kilos and at the end of the statement you were told it was weighed 50 kilos, then, you know, you have to take that back to your witness and get them to be clear about what it is that they mean, because they're the types of inconsistencies that will cause considerable difficulties defending a claim that makes it into common law. In the statement, identifying where everything occurred, so where the witness was, where the incident was, where all of the relevant gear was, is really key. You know, if an incident occurs in a big premises and the witness tells you it happened in the hallway, that's going to cause considerable challenges for the defence of the claim down the track. So which workstation, which hallway, which corner, which room, try to identify as clearly as you can exactly where the alleged incident happened and exactly where the relevant people were in proximity to it. That becomes really important in common law claims. In terms of how the incident happened, this is relevant, I guess, if you're taking statements in particular from leading hands and team leaders. If an incident's occurred, well, what was the right procedure for the work? Was it followed? And if it wasn't followed, why or why not? What instructions were given and what training was given. Those issues are really important in terms of defending a common law claim down the track. The why bit for witnesses is a bit of a challenge, because you don't want a witness to speculate, but if a witness has direct knowledge about why a system wasn't followed or why an incident occurred, you know, for example, if a witness was standing behind a worker who was chatting to a co-worker and not paying attention and has managed to injure themselves, like that's the type of information that ought to go into a statement. And then do we still have contact details for all of the relevant witnesses? So maintaining relevant files so that, to the best of our knowledge, obviously workers move on and by the time the common law claim is lodged, we can be 2 or 3 years down the track from the injury and workers have all moved on. Do we maintain contact details for witnesses? So at least we can go and track down these people years after the event if we need to in the process of the common law claim. So this is a little bit more information about how to take a good statement. What did you see is a great question. And as I mentioned before, how do you know that and where were you are really powerful questions. Be objective and impartial. So you are fact finding at the point that you're taking these contemporaneous statements. Record the inconsistencies, as in if your witnesses are giving inconsistent versions, it's important to record those because that'll need to be investigated further and tested. Recording things in neutral terms is important. I think demonstrating, particularly when you get to the common law claim stage, that what you were doing was fact finding and that you hadn't reached a conclusion prior to concluding any investigation. I say there, let the witness tell the story. One of the most effective things you can do when you start taking a statement from anybody is to start by saying, what do you want to tell me about this incident? And just let your witness talk and tell them everything that they want to tell you, and then take them back to the start and ask them the questions that you want to ask them. If you don't let your witness get their version out first, often they're not listening to you and they're not concentrating properly because they just want their turn to talk. So I always let the witness tell me everything they want to tell me, and then take them back to the beginning and step them through everything that happened and how they know, what they know, where they were. And I've said there again, because it's important, first person accounts in the witness's own words. It can be tempting once you understand the system of work to take statements from 3 workers and describe the system of work in identical terms, but that doesn't assist you, and it doesn't assist with the weight or the quality of the statements that you'll take. So take your time and record what the witnesses are saying to you as they say it. Doing the interview at the scene can be really, really handy if it's possible. To make sure that everybody understands, firstly, that we're using the same technology, that we're referring to the same equipment, that we're referring to the same place. And then come back to the witness to ask further questions if your subsequent investigations reveal further issues. Obviously, get your statements in writing and signed. It is really good practice to offer a support person to a witness if one is requested. Choose somebody who's not involved in the incident and who is just there as a support. So that person shouldn't be able to verify evidence that's provided by the witness at the time or assist them to fill in the blanks. And absolutely, whatever you do, don't interview witnesses in the presence of other relevant witnesses or their manager or supervisor. Unfortunately, that happens a lot when an incident's happened at work and something's gone wrong, and the person doing the investigation really just wants to get to the bottom of things straight away. So they pull people off the floor and their leading hand or their supervisor comes up with them. And it can just really impact on the quality of the evidence and the reliability of the evidence the witness is going to give. And it doesn't help down the track when it becomes apparent that a witness is unreliable because they haven't said what they needed to say because they didn't want to say it in the presence of another worker or a more senior worker. So obviously, in a perfect world where time is unlimited and dollars are unlimited, you could do a Rolls-Royce investigation on every incident that occurred, but obviously that's not practical. So I guess judging from the type of incident, the type of person involved, and a degree of forecasting, I guess, to determine what's a basic level investigation and how much further than that do we need to go. Larger employers that have had exposure to common law, I guess, have a better sense of the types of injuries or the types of workers where common law claims may result. Obviously, the more severe an injury is, clearly the more careful and detailed the investigation needs to be. And obviously, there are workplace health and safety reporting obligations and investigation requirements. So in terms of yellow flags, these are, I mean, hindsight is a perfect thing, and many employers get to the end of the common law process and they say, you know, I had no idea at the time this claim was lodged that we would end up, you know, all the way down this track after, you know, several years and lots of dollars and lots of stress. And of course, we can't predict which every claim that will become a common law claim, but these are the sorts of ones that you might want to think about. Where there has been a significant delay in the reporting of the injury, or the mechanism changes over time or is inconsistent, where a worker has ongoing issues with management or performance or human resources, where your initial investigations reveal conflicts about the versions or the evidence or how or why the event happened. I've said the type of claim there, but it's difficult to know just looking at the type of injury whether or not a common law claim will result. But early requests by solicitors for copies of documents is probably one of the earliest indications that employers might have of a worker's intention to take matters further. So, I appreciate that employers work within separate systems, and a lot of what we see when we ask for investigation documents is that employers have to pull a series of documents from different areas of the business. That creates challenges because people leave different areas of the business over time, so there's changes in record keeping, there are changes in systems, there are upgrades, and then old systems aren't available, and you know, there's an enormous amount of time and effort that goes into by employers to obtain the documents that are required. And I appreciate that what I've proposed may not be possible for employers for a number of reasons. But I guess once an employer knows that there's an accepted statutory claim and it looks like a common law claim might be on the horizon, whether because they're receiving requests from lawyers or they're having difficulty managing their workers' return to work, or the employee sometimes expresses an intention as regards common law. In a perfect world, this is what your panel lawyer would absolutely love to receive, which is an investigation folder which is a living document into which key pieces of evidence and key documents are placed throughout the course of both the investigation before the statutory claim, and then the common law claim. So copies of relevant documents, incident reports, risk assessments, you know, all of those key documents, training records, copies of statements, photographs, contemporaneous photographs of the area. That's one of the most powerful pieces of evidence an employer can obtain. Everybody has an iPhone now, and I appreciate that there are some workplaces in which there are restrictions about how iPhones are to be used in certain areas of the business, but where you can, if a worker comes and reports an incident and says, I was lifting a box or I tripped on a step, the most powerful thing an investigator can do at that point is to go and take a photograph and ask the worker to tell you, is that the box, is that the step, is that the handrail, is that the piece of machinery, and take a photograph of it, which will cut out many, many hours and a lot of heartache in the following years when the common law claim comes to try and prove, well, was it that staircase, or was it that box, or was it that piece of machinery, and preserve the physical evidence. It can be very tempting to throw out the broken chair or the ripped rug or whatever it was that's involved in the incident. But if you can hang on to it and be able to preserve that piece of evidence later on, that can be absolutely key, and in fact can be the key thing that can assist you in defending the common law claim. So I guess from our perspective, they're all the things that we would love to see. And I appreciate that what we ask from employers at the lodgement of the common law claim when we're going through the investigation piece can be very difficult and very time consuming. And I guess that's where it's a good point to hand over to Matt, who's going to talk about how WorkCover can support employers with some of that.
Thanks, Kerrie, and thanks, Tim, for your earlier introduction. Thanks, everyone, for tuning in to listen. So WorkCover have introduced the Early Investigations Pilot Program. It kicked off in November last year and has been up and running at full steam since early 2022. Okay, so the aim of the program is to identify existing statutory claims that are considered to be at high risk or at greater risk of proceeding to a claim for common law damages. So we've used some data to try and extract statutory claims that fit that criteria. One of those is the mechanism of injury. So as an obvious example, a worker who falls off a roof, for example, something's gone wrong there. Workers shouldn't fall off roofs. So workers who have fallen from heights, that's one category or injury description that we capture. So typically that'll produce injuries sustained by scaffolders, roofers, solar panel installers, and tradespeople generally. So and on top of that, within WorkCover, we've got what's known as a pricing and data analytics group. In-house, they're known as Panda. And Panda have identified a strong trend that workers in the course of the statutory claim who experience issues with coping or feel they lack employer support or they develop secondary psychological injury, those sort of factors are a strong indicator that those sort of claims are more likely to proceed down the common law path. The claims where those factors don't exist. We also look at things like the severity of injury. So if a worker hasn't returned to work, that's another yellow flag, as Kerrie mentioned earlier in her presentation, along with the involvement of solicitors. So when we see on the statutory claim that there's been a request from a solicitor for the worker's statutory claim file, there's probably no better indicator of common law potential than the early involvement of lawyers. On top of that, also been getting feedback from customer advisors who are at the front end of claims, and they're best placed or often best placed to deal or identify statutory claims that are at risk. You know, they're dealing with the worker on a pretty much day-to-day basis, and they can identify those yellow flags. So that's another source of useful information. And also speaking to employers out there now, it may be that you've got statutory claims that you're currently dealing with, and you feel that there's issues attached to them that may see them going down the common law path. If that's the case, please feel free to get in contact with your relationship manager or customer advisor, and we can take a closer look at the claim and see whether it's suitable for early investigation. Thanks, Kerrie.
That's it, yeah. All right, thanks, Matt. We've had some questions come through, quite a few come through, so I'll just have to sort of pick some out and put them to Kerrie now, if that's all right. So we'll start off with, someone's asked, can there be a common law claim for a journey injury?
Well, the short answer is yes. If a worker is a passenger in a vehicle, there could well be a common law claim, but of course the common law claim will then be against the CTP insurer, so the motor accident insurer of the vehicle that was involved. Where there's a single person in the car, and so the worker is in the car and the worker is at fault, it's less likely. but it still is possible. There's a category of claims, for example, in which shift workers are coming off long shifts and driving home and have had accidents. So fatigue, where they claim that fatigue has been the cause of the accident. There's been a series of those sorts of common law claims. So yes, but they're not very common, I guess is the answer.
Yeah. All right. Next one, who has the burden of proof at common law, and how often do you see common law claims where we dispute liability?
So the worker has the burden of proof, and the standard of proof is on the balance of probabilities. So the worker needs to prove that it's more likely than not that their injury occurred. Liability is frequently disputed, and claims can be resolved for a series of reasons, including where liability is disputed, and every claim that is settled is made without an admission of liability. Excuse me. So I would say we take a fairly strong position on most claims, and liability is an issue.
Yeah. Excellent. All right. You mentioned in your talk looking out for ongoing HR issues. Someone's asked what sort of HR issues might impact on a common law claim, and how might they have an impact?
When a worker's already in performance management, when somebody's been stood down, when they've received a first and final warning, those are sorts of issues where the worker then may leave work or go home for the weekend or come back with a claim of their own. So not to say that people can't be genuinely injured in the course of being performance managed or having other surrounding HR issues, but it is a definite time where we see an uptick in claims, particularly in bullying and harassment claims. So where a worker's already going through performance management, it's really important to document at that stage really carefully what's happening, why the process occurred, what the employer is doing and not doing, because they're the types of issues that need to be investigated very carefully if there is a resulting bullying and harassment claim.
A couple more have just come through. I'll put two more to you, I think, if that's all right, given we've got some time. So one of the questions here is if a worker has had a final payout from WorkCover, and I assume that means a PI, lump sum payment, can they still do a common law claim? So there's some tricks there.
Sure. So under the legislation, if you receive a notice of assessment and your permanent impairment is assessed at less than 20%, and you accept the offer of lump sum compensation, that extinguishes your common law rights. However, if your impairment is assessed at 20% or more, you can accept the lump sum that's been offered by WorkCover and still pursue your common law claim, and that's just a provision that's provided in the workers' comp legislation. Of course, the impairment lump sum that you receive is counted towards the damages you ultimately receive. So you don't get the lump sum at statutory stage and then your whole damages. It counts towards the damages that you ultimately obtain.
Might just do one last one, which should be relatively straightforward. Do workers have to write their own statements, or can an investigator do it for them and then they read and sign off on it?
An investigator absolutely can, and it happens all the time. Lots of us have workers from varying backgrounds and varying levels of education and experience, and that can be a better way to do it. And I guess if the investigator is doing it, you've got more of an opportunity to ask questions and include additional information that the injured worker may not complete or provide if they're doing it themselves.
All right. I think we might just leave off the questions there. I know we're finishing up a bit early, but they're sort of coming in fast. It's a bit overwhelming. All right, I'll wrap up the session. Thank you very much, Kerrie. That was terrific. Some good insights there about what employers can do to manage workplace injuries to improve claim outcomes. Thank you, Matt, for talking us through what you do as well. It was really interesting. That concludes today's webinar. A big thank you to Kerrie for presenting today. We appreciate the time and effort you put into preparing and presenting. For our audience, thank you again for tuning in this morning. We hope you found this session informative and helpful. As mentioned earlier, this session is recorded and will be sent out to you early next week and also uploaded to the WorkCover Queensland YouTube channel, where you'll find all our previous common law webinars in a dedicated playlist. That's all from us today here at WorkCover Queensland. We hope you have a great day. Keep an eye out for details on our next webinar, which will be sent out by email if you have registered for this session. It'll be on LinkedIn and it'll also be on the WorkSafe website under events. Thank you all very much. Stay safe and have a great rest of your day.